Thanks, Bruce. Okay, what we're going to be talking about today, because up until now we've all been engaged in the overall mission of raising awareness, trying to get better understanding of IP. What we're going to be talking about in this session is how, and are there methods that have been helpful, not helpful, and what do we know about their effectiveness? And we're going to be talking, I think, about a variety of audiences. We're not necessarily going to be debating which is the best, most necessary, most immediate audience, but we'll be talking about undergraduate and graduate education, young children. We've already heard mention of the National Inventors Hall of Fame programs. We'll be talking about Congress, the judiciary, the media. We'll be talking about researchers and their management, all of those people. But how do we get the message across to them? We'll hear about a number of different techniques, videos. Somebody may mention the Velcro video, and everyone, after you're finished here today, go see it. We're going to be talking about education that takes place about IP, not in the law school, but in other university settings, and in completely different contexts than lawyers are used to hearing it. We'll talk about whether and how we are able to measure the effectiveness of any of these techniques and programs and the struggle around that. And finally, I think throughout, we'll probably be addressing the challenges that are faced by educators, by anyone who's trying to raise awareness. There are attitudes out there. And I think earlier today, we talked about teenagers who think that IP is annoying. Well, you know, you should try spending some time in Geneva and find out there are a lot of people out there who think it's evil, absolutely evil, and the new colonialism. So at an international level, there are some specific challenges. At the same time, we've heard here that there are a lot of advances which we should all be happy about in the international sphere. And when we see something like what has happened with China, one might be tempted to say, well, what happens with intellectual property anywhere is that once you get that you have a domestic innovation issue that needs support from a framework of intellectual property, well, then it happens organically. Did education have anything to do with it? Did any of our trips to China to talk to them about, you know, the importance of IP ever land? You know, we really don't know. So let's start by getting into the current state, what everybody thinks is the state of IP education today. Are we moving forward? Have we dropped back? Are there new exciting things happen? And we're just going to open this up to folks on the panel. We have, as you know, a couple of academics here, and so I'd be very interested, particularly in hearing what you see happening at the university level.
You get to go first.
Yeah.
Well, thank you,
James,
for the opportunity. The university environment is one that is institutional methods and traditions that actually track a very predictable path of learning and development in a particular curriculum, right? I mean, our friends in the medical school can go all the way back to Hippocrates and the like, and things that you are going to actually introduce to what the student will learn that has to be a little bit different than what is outside of those traditions, or can't be measured in a way that isn't commensurate with the research methods of those schools, are viewed with great suspicion, as they should be. But there's some good news about this with respect to working IP into, for example, the context of the design curriculum, the management curriculum. Bo will have a lot to say about this. There is a great paper that was actually written by David Teese, who's right in front of us, that was about 1986. That's when all of this shift from tangible basis to intangible valuation started to occur that really brought into focus the role of property rights. He talked about it in his own presentation. And now that paper is, what, almost 30 years old now, David? Right? Now, luckily, that thing has more citations than just about any other academic publication in some of our top journals. Right? Now, I know this. Bogue know this. Few people know this. This is one of the important elements of arguing for how you bring IP into the center of the management curriculum. This is evidence, right? So what we have done at Northwestern, and what a lot of some of my students here, my postdocs are actually at other universities, what have they done? They've started to compile this and use this as what we call the epistemological foundation, the knowledge foundation. It's not just this, it's things that go back to the 16th century, which show that property rights, as they've evolved to be named, are actually very important in promoting certain free market innovation systems. That's a word that I used earlier. The latest issue of the National Academy of Inventors actually is dedicated to laying out this path. What's the epistemology? How do we teach this? And how do we actually create a pedagogy that's easily adaptable, not just here in the US, but in Sweden, in Asia, and other places? We must actually elevate this, as David has said, to a geopolitical issue as we create this epistemology and this pedagogy. It's happening, but it takes resources. And as David and I were chatting, and Bo knows, we as individuals don't scale very well. So, we need other ways to do this.
How about scaling?
We need scale.
And that's why I'm interested in seeing some of the other technological solutions that are coming through the Michelson Foundation and other places.
Okay, from your enthusiasm, it sounds like you don't have any trouble getting the attention of those that you're trying to educate. I mean, does this really matter?
Too enthusiastic.
I was too enthusiastic?
No, I'm just teasing.
Okay, now, I don't really use the word property much in my classes. I use the word intangible assets a lot, and this is a good thing and it's a bad thing. Sometimes the students get the message about property. It's clearly there in half of the class. But then they also get other ideas that they pick up in other areas of the curriculum. The anecdote about that is I got called by a very enthusiastic former student that said, "Professor, we need you to come and sit on this board of directors." I was very interested in serving in this capacity. And then I went and visited with the chairman, and he said, "Now, what I really need you to do is, when you're on that board, you got to advocate for selling this IP portfolio. We need to sell that damn thing, and we need to get the dividend out to pay the stockholders. That's exactly what I want you to do. You just go ahead and do that." And I'm thinking, he certainly isn't hiring me for the way I think, right? He's hiring me for doing his task of actually sending this message of using IP to get to a dividend event. And I had to decline it, right? I mean, this would clearly be something that would undermine my objective view, but that's actually how the students are sometimes seen. Yeah. Right? That's not necessarily a bad thing, but they're finding it can lead to all sorts of other things that may not be part of what is a great story. But that's just the nature of knowledge. It tends to happen that way. Yeah. We can't control it. We just have to see where it goes.
Oh, what are you finding works?
Yeah, it's difficult to get people to opt into studying intellectual property outside of the legal profession. In Sweden, it's called immaterialrätt, which is similar to the German. So you talk about immaterial rights. It doesn't even have the word property or assets in it. It sounds very legal. So the best thing, of course, is to force people to take the course. and as you said, that's not so easy because course time is like beachfront real estate. That people don't give up very easily. But what we find is that works is that you don't talk about it legally. Even if you're working with lawyers, you start out by teaching what is it that you want to accomplish, because intellectual property is a tool. We made it up, and it's like property, a tool for accomplishing something. And what is it that you want to accomplish? And it's not that difficult to explain to people a lot of value-creating examples in the world that are all built on intellectual property, brands, and software. Even open source is built on intellectual property. So you start there, and that tends to work, because if you start there, then all of a sudden they'll start to ask you these questions. Well, where do you file for a patent? How long can you have it? Well, why can't they start to ask you the details? But if you start with the details first, the legal details, you don't go very far. In fact, we ran a course called The Business of Intellectual Property. It was an executive course, and only people with patent in their title came to it. And then we ran a course called Advanced Innovation Management. And I got R&D people and business people. I taught the exact same thing. They loved it. So you have to, so you have to trick them. And the last quick thing maybe is, as Professor T said, is that we tend to think about intellectual property. I think we still teach it a little bit too much, even when we do teach it in an industrial way. We teach intellectual property for an industrial era, not for a knowledge-based era, not in a place where we want the division of innovative labor. And this is something different. This means intellectual property is the key to openness. It's not economically a monopoly or just an incentive. It's actually a way to package something and transact it.
And encourage sharing.
And that's completely different. That's a game changer that people leave out all the time.
Yeah. Well, Molly, you have a different audience. You're doing public outreach to some. Do you feel that you're trying to boil the ocean sometimes?
Oh yeah. No, right. I joke that the U.S. Patent and Trademark Office will talk to anybody about intellectual property who will listen to us for as long as they'll listen to us. But yeah, we do a lot of outreach to various stakeholders, whether it's independent inventors, startups, entrepreneurs, the K through 12 crowd, university students. We just did an interview outside, and I said, you know, every moment is a teaching moment. I used the Trolls. The new movie Trolls, where Anna Kendrick and Justin Timberlake are, you know, singing September. And my 8-year-old son thinks that September was only ever done by Justin Timberlake and Anna Kendrick in connection with this movie. And, you know, I'm from Denver. Philip Bailey went to East High School in Denver. So I now get to introduce my son to, you know, the realm of copyright and the fact that no, you know, Justin Timberlake and Anna Kendrick didn't come up with this, but, you know, it was really Earth, Wind, and Fire. And so you use those teaching moments all the time. And, you know, I mean, my son, unfortunately, happened to be the recipient of that one, but I'll work that into a talk sooner or later. But we do. You know, we talk to people from different high schools. We'll talk to universities. It's all about taking the message of intellectual property and what it can do for you and making it personal to them. So you have to know your audience, and then you have to tailor that message as to, you know, where it's going to go. And a lot of times we start with the idea that intellectual property creates jobs, and I have to thank Patrick for that because I use his stuff quite a bit in that. And that's typically when we start with IP creates jobs, that's where people get interested because now they want to see how that works.
Yeah. Speaking of jobs, you work with a lot of people who are inside the organization actually creating the innovations that need to be protected. And you've had a lot of experience teaching them, right? Those who are in R&D, those who manage, those who are in, what special challenges and opportunities have you found? What works in that environment?
So you're giving me the spotlight,
I'm
right?
giving you, all
right, everybody.
Take it.
Here we go.
Take it.
Okay, here we go. So it's several years ago. I'm at an LES meeting. Judge Rader was the speaker. Before the meeting, because of the prevalence of these devices, I pronounced the ADA rule, which is anyone whose mobile device rang, sang, ding-donged, or whatever would be able immediately to write a check or give us cash or give us a credit card for $100 to the 501c3 Educational Foundation. So, Judge Rader finishes his talk and all the patent lawyers line up to talk, and honest to goodness, one of their phones rang. And I flew across the room, and it was none other than a Houston patent attorney, and he pulled out a roll of $100 bills. He gave me $100 on the spot. And do I have to tell you that I thought I had put into the closet the problem of people spending more time looking at their device than they did listening to the speakers and learning. All right, so I was wrong. I do a lot of teaching. I created the Intellectual Asset Strategy Group for all of Upstream, and I generally taught 20 9-hour days a year all over the world, taught for LES. I started life as a chemistry teacher in college and a dean of a college. And what do we know about chemists? We're kinesthetic learners. We like to stir. We like to measure.
We like to stir.
We like agitation. We like putting heat into things.
Chemists, we stir
We
things
like
up.
all these
It's a good
things.
tagline.
And so lo and behold, along the way, I also was on a school board. And this is right at the time that the learning style changed from workbooks to hands-on learning. And it's known as Sage on the Stage, going to hands-on learning. I adopted it, and it's worked for the rest of my life. And so what we did is in 2015, we created a new course for LES, and it's called Business Basics 101, Connecting the Dots Between IP and Business. And I took all these lessons from upstream because I can tell you, getting a drilling engineer interested in reading patents and license agreements, I really can't think of anything much harder to do. All right? So our course now is taught pretty much only in the US and Canada because finding instructors who are willing to play some theater are hard to get. We start the day off with candy at 8 o'clock in the morning. We teach them about trademarks. We teach them about brands. And I go to the stock market analyst to get the value of candy companies and the value of brands. We're connecting the dots, you see. And then we have them do a product line extension for a candy product found in an aisle in a grocery store, not in the candy aisle. And we have had some hilarious new products, some of them being things like Snicker flavored vodka, okay, and on and on and on, okay, but it can't be in the candy aisle. And then lo and behold, we use a source called KT Mine. It's a Chicago company. They collect the SEC documents. And I have a major candy company who has an agreement for a product line extension with a small company in the Southeast. And we teach them to read the agreement because one of our takeaways is the business owns the result of the business deal. And you should hear the moans and groans we hear about people saying, it's an ugly, it's one-sided. And I'll say, yes, but they renewed it. So one of the things is you got to show there's business value in doing this. So by then we've got them chugging along, okay? And then the next thing we do is we actually do IP improv, acting out what a trade secret is, using a story, a real story of a bar in in New York, down south of Soho, down around Soho, right? And we have bartenders, we dress people in the class up like bartenders, and you know, it goes on and on like that. And then, guess what? We moved to beer to teach them how to do invention disclosures. And they each have to come up with a solution to save the beer from a problem, and we do have to save the beer. And then we use that, and we find a patent, and then we teach them how to read a patent, and we actually act out what the elements of a claim are. And again, we play theater to act out, imagine what a claim is. When we do this with trade secrets, we eliminate at least 25 slides. We never, if anybody's in a business, I don't care whether they came from research into a licensing position or were a salesman or whatever, if you don't work in an area that uses trade secrets, all the words on 25 slides do not answer your questions. Acting it out with people in simple costumes, we've never had a question ever since then, okay? And we even, when we do our claim thing, we act out what the doctrine of equivalence is. It's been wild. We end up doing 3 total agreements, several patents, and we teach them how to read, how the buddy system works.
And they're all drunk.
And at the end of the day, the last thing we do is a tequila distribution agreement. Then we have a party and serve all 3. And we had somebody just finishing a PhD in Madison who took the course, and she stood up at the end and she said, now I know what I want to do for the rest of my life.
Drink
Isn't that
tequila?
fun?
No, no.
Bartender.
She wanted to do licensing and do intellectual property because it's engaging, it's fun, and we keep the energy up and keep everybody moving around.
Well, I think everybody here wants to take your course.
Well, they can. Yes. It's at LES.
So this is really great. Help us understand how you measure the extent to which those lessons land and stay. In other words, what effect have they actually had? Can you measure that?
Yeah, we teach them how to do SWOT analyses
Yeah.
and doing Monday morning quarterbacking of reading license agreements. So when I was at BP, I routinely read 300 to 400 agreements a year, and I can actually reverse engineer to get the business strategy from reading an agreement now. It's been really fun. So we really connect the dots for them. So we actually go around and we do feedback. We prefer to have groups of 2 to 4. If you have a group of 5 or 6, 3 or 4 of them are looking at their mobile devices and they're not paying attention to what's going on. So the engagement model works. They do the reading, and they're so proud of themselves. The first reading of the first agreement, everybody's thinking, get me out of here, get me out of here. So we have to keep feeding them candy, and having some fun. But we work the room, and but every exercise gets feedback. And we ask them after every exercise, what's your takeaway?
Yeah, great.
Okay?
Great. So thank you. We'll come back. Patrick, the Chamber instituted GIPC a few years ago, and its stated goal is aligned very much with what we're talking about here, raising awareness and doing that, I suppose, somewhat within the business community itself, but who are the other audiences that you're trying to reach?
We're an advocacy organization for business, and as you said, our mission is to raise IP standards around the world, including here in the United States. And by that we mean broad eligibility for intellectual property rights, limited exceptions and limitations that are clearly defined in law, strong, reliable property rights that are not easily or arbitrarily dismissed. And so we're arguing consistently for those everywhere in the world where
is that with governments?
Companies do business with governments. We're trying to affect government policy. And I think the most important thing, is to remember that no institution is monolithic. So when we're talking to the government of Indonesia, for instance, and we're running into, a desire out of the health ministry to drive compulsory licensing of pharmaceuticals, then we're making sure that we go to the Ministry of Economy and the Minister of Industry and inform them with arm them with the facts. And when the cabinet meets and the health minister gets up and pushes a compulsory license, they've got the arguments to say, well, we're going to lose out on investment. Our local artists, or they're not going to be as strong if we weaken our copyright. And we find that ability to divide and conquer, identify the people that are more aligned to our point of view, and arm them with the facts. You asked about, does that stuff make a difference? And I pointed to Judge Rader here, who, together with Dave Campos and several other U.S. experts, sits down a couple of times a year with a group of 5 Chinese experts for the U.S.-China IP cooperation dialogue. They have been so effective that I think we worry that we've given away the secret sauce. Even in India is a very difficult market for IP-intensive industries to do business, and yet over a number of years of concerted efforts, so, we started by sitting down with editorial boards, highly skeptical of IP. We didn't ask for an interview, didn't ask for any coverage, just said, let's sit down for an hour, 2 hours, as long as you want. Ask us all your toughest questions. We go through them, actually make the case for why IP is necessary, not just for our companies, but for their companies, how it actually facilitates innovation at the domestic level. And you know what? They started to pick up our language. We started to get more balanced coverage in the Indian press, and they started to independently challenge the Indian government on some of these issues. It takes time, it takes focused effort, and it takes repetition and consistency. I feel, as I look, and I'm not the domestic policy advocate for the chamber, but as I look at the domestic market, you can't help but feel somewhere we got complacent, and that I look back at the SOPA fight, and I see the companies around our table that are more patent intensive, thinking, oh well, thank God they're focused on the copyright guys. Those poor suckers really got screwed. But meanwhile, that's, in retrospect, that was a much more holistic effort to undermine U.S. intellectual property, not just U.S. copyright, I think in retrospect, it seems to have been a much more systemic effort. And we need to be in first, arming our allies with the facts. This is the reason, the Chamber, among other things, we've got what we call our 10-10-10 program. We've identified 30 members of Congress. I'm not going to tell you who they are, but we have a tier of existing champions, people who have been around for a long time or are strongly pro-IP. We've got a second tier of mid-term members, members who've been around for a few terms but maybe aren't committee chairman yet, but have a generally pro-IP record. And then the most important group, we've got 10 freshmen or second-term representatives and senators. And what we do is we just constantly inundate them with positive reinforcement. Whenever they say something good about IP, and we amplify their message. We do in-state meetings where we bring in local companies to talk with them about IP. And this is a relatively new program for us, but it's
behavior modification.
It really shows results, and we need to do much more of that as a community.
Well, that's great. I mean, it sounds like internationally, at least, things are moving in the right direction, but we really have challenges domestically, right?
Yes.
I mean, yes. Thanks, Gene.
Patrick, you were just talking about meeting with the Indian media, and I was wondering, have you had any similar meetings or attempted to have similar meetings with U.S. media? And if yes, I wonder if you might be able to compare the two.
The irony is that sometimes it's much easier for us to get media overseas than it is at home. And it's frustrating for us because we think we have a lot to say. Part of the problem is, as a big, mostly domestic organization, we have other institutional priorities that crowd out. Even some, we can get a little bit of attention, but not certainly the level we'd like. When we go overseas, we are, the U.S. business community really speaks loudly there, and we're able, frankly, to get a little more attention.
Yeah. What? I want to get back to this issue of measurement. How we've talked about a variety of ways in which we can approach and we hope influence a variety of audiences that presumably matter. How do we figure out when we are having an impact, when we're actually moving the needle? Anybody?
Yeah. Well, one of the things I've learned that you've got to have a plan and you've got to have a measurement before you even teach the course or begin engaging. Because if you wait till after the event or the course, it's almost too late to figure out what it might be. And what I've learned is on measurements that generally you modify them after the first couple times you provide the instruction or the interaction or whatever. But you always want to measure, but you want it to be a measurement where that person can articulate at least 3 things he or she has walked away with at that event, and that they feel good about it. So that's always one of our measurements. Did they feel good that this was a good use of their time? And we have qualitative measures that we do at the end of every class.
That's great. Anybody else on this?
We do some surveys, especially with our STEP program, so I don't know if all of you are familiar with that, but it's the Stakeholder Examination Practice and Procedure Program. Maybe that's 3 Ps. I don't know. Anyway, I get lost in the government acronym soup. But it is basically taking our Patent Training Academy that we give our new examiners. They spend 4 months in the Patent Training Academy. We boil it down to 3 days for all of you. And it's usually geared at the 0 to 3 year attorney. And then, we do it at Alexandria. And then we also rotate it through the regional offices so that everybody has the opportunity to go to a STEP class in their region. And at least last year, the regional offices were responsible for training 189 patent practitioners as part of that STEP program. And it really is. I took it, and I probably hadn't thought about 102 in that depth in over a decade. So it really is a fantastic program. And then we survey people afterwards, not just like right afterwards, but then we also go back and we ask the people who have said that they're willing to be contacted because of course we have all the restrictions on, with the Office of Management and Budget and the Office of Personnel Management, that we have to make sure that we're informing people that we'll be contacting them again to see if they implemented any of the things that they learned from STEP in their practices. And it has worked out really well. That's probably the exemplary program where we're able to measure impact, but we're also having a conversation with the entire agency about how we measure outreach and education and what that means. The regional offices, I think, are the game changer in that one, because we're able to be out there a whole lot more. That's, a significant part of the mission of the regional offices, is to go out and do education and outreach. And I think in FY17, the regional offices held over 1,000 events, reaching about 80,000 independent inventors and IP professionals. Some of whom I know anecdotally told me that I'm the first USPTO official that they'd ever seen.
Wow.
In their hometowns. So,
good for that. I'd like to just shift and ask the academics. Since you've been in these programs for a while that introduced IP into a management curriculum, have you been able to follow the careers of people who have left, or the actions taken by them that might give you some hint as to how well your teachings landed?
I can go ahead. Yeah, well, I think the first thing I realized when we did this, because when you weave technology management, business strategy, and IP together, so we don't teach like law and then technology or management. We weave it all together. And when you do that, I realized that when I sent out my students to do summer internships, they were already getting job offers. And they're halfway through the program. Then I figured that this was some type of combination of things that not only were they learning when they went out there, they were actually able to give something. Okay. And this kind of weaving of these different things together creates a whole different experience that I think allows for this to stick much better. The one thing, the negative side of this, is that if you teach people to be very good at this interface, there's other actors other than IP actors that would like to have your students. So it's very difficult. Once you teach people this interface and you say, well, you can go work at McKinsey, or you can start off at the lowest level of the IP department of a company, they go to McKinsey. So I think as an industry, we haven't created an IP strategist role. There's no management trainees in the IP department. They're everywhere else, but not there. So we talk about IP management, but no management trainee program.
Some companies have.
Yeah, James, I see you nodding.
That enrollments are the most immediate short-term measure. And when I started teaching this class, I had 15 students. That was in late 1990. I teach over 500 a year in various forums, in the Middle East, in Europe, in Asia, and on campus in Evanston. A lot of this content is broadcast around the world asynchronously. That's one direct measure. They come back to me now with the case studies.
Yeah.
I needed I had a great case study. Some I learned again from my friends at Berkeley, like Ray Goldie's story is an incredible one. But I just picked up this one about Driscoll's strawberries. I mean, we all know Driscoll's strawberries, but that's actually the product of the University of California. The University of California, Davis created that sort of genotype that fed the farms. They didn't have any real branding interest. But then one of the farmers, Driscoll's, decide, oh, I can see the whole value chain. I can actually extend my brand all the way to the retailer and own the trademark, right? And there's a premium associated with it. It's really very simple. Someone else came to me with the Honey Crisp apple. If you have 5 kids like I do, they eat these apples, and they don't want any apple, right? They want the Honey Crisp apple. Right. And the Honey Crisp is twice as expensive as all the others. Well, why is that? University of Minnesota patent. Yep. I mean, there's all these angles here that are coming back to us to give us a richer story.
Publicly funded money going back, costing us.
Yeah, it's a great story.
Taxpayer.
One last question I want to ask you, then we'll see how much time we have for additional audience questions. What technologies or techniques beyond Ada's improv in the classroom have you found have been useful in imparting understanding, broad understanding to these various audiences? I mean, we mentioned videos earlier. In one of the breakouts, there was a mention of someone brought up the IPO Education Foundation videos. and suggested, you know, these things are really cute and we all like watching them. I wonder how much impact they have. Can videos be helpful to you in this process? So how? Where? Other technologies? What are you using? Can we use social media? For
yes,
example?
I think videos are good, but remember the short attention span today. And some people put out these videos that go on forever and ever and ever. And years ago, I was working in a chemical company, and I was talking to my division president about something he was very interested in. And I actually timed his attention span. I'm known as Ada Data in some circles. And it was 53 seconds. Okay? So I think it's really important. So I think the videos are a good idea, but just remember how short attention spans have come.
Yeah.
Well, what I like about the videos that I referenced earlier, they're actually not from the IPO Foundation, they're from the Michelson Foundation, but they are only 4 minutes.
Yes.
Okay? And they are taught outside the classroom. The students actually can consume this while they're multitasking, you know, in so many different dimensions as we all do. And it's digestible. That's what I like about that particular thing. It's asynchronous that you consume. And then when we get back to class, we can drill down on that. That's just a flipped classroom methodology, which is a different form of pedagogy.
I have one other quick thing. Is everybody here familiar with the Gunning Fog Index? It was created about in the 50s for readability. And you used to have to calculate it by hand, number of 3-syllable words that are not ordinary, and how many words in a sentence and so forth. Well, now guess what? All you have to do is block and copy a section, put it into some websites, and they'll tell you what the Gunning Fog Index score is. A score of 12 says you need a high school education to understand it. A score of 16 says you need a university college education after that. 20, you need graduate education. One time I took the reps and warranties of an agreement I was working with, and I put it in, and take a guess at what the Gunning Fog Index score was. It was 36.3. Now, if in fact lawyers are writing this for the benefit of a jury, I'd like to tell me where they're going to find a jury where the average person is. So again, I would suggest testing your readability, whatever your social media is, the readability, understandability, it's really a big deal.
Good point.
It has got a really important point. You know, everything, videos, social media, print media, whatever it is, it's a vehicle for a soundbite. Ellen Dixon was reminding me of that earlier. You know, language is so important, and the goal, certainly in Washington, any government, is to get people repeating your language. The patent control people did that very successfully. We need to be more successful. We need to get the marketing people involved.
Any questions out here?